morning, everyone. Senate Judiciary Committee is called to order. We have on our agenda this morning a hearing on Senate Bill 301. If we could have a bill brief from Mr. Reviser, Mr. Thompson. Thank you.
Thank you, Madam Chair. Good morning, committee. This is Jason Thompson with the Office of Revising Statutes. You have a fairly substantial bill brief in front of you. I won't go into the detail of that. I'll see what questions you have maybe more specifically, but I'll give you the brief kind of overview here. Senate Bill 301 does two things. It establishes the Office of the Child Advocate within the Office of the Attorney General. It also creates the Joint Committee on Child Welfare System Oversight. So new section 1 names our new sections 1 through 5, the Child Advocate Act, and gives some definitions. The key definition is child, which only means those individuals less than 18 at the time such individual is receiving services from Department for Children and Families, DCF, or a contracting agency for whom DCF has an open case file, or who has been, or whose siblings, parents, or other caretakers have been the subject of a report of abuse or neglect to DCF within the previous 5 years, or individuals less than 18 receiving services, treatment, or other programs from the Department of Corrections, so probably on the juvenile offender side. Those are the children we're talking about when we say child throughout this act, only those identified there in that definition. New section 2 then establishes the Office of the Child Advocate within the Office of the Attorney General. There's a lot of provisions in there about this individual and what they'll do. I'll note they're appointed by the Attorney General. They're subject to Senate confirmation. They have a term that expires with the terms of senators. So the maximum term will be 4 years, but it could potentially be much less than that depending on when they're appointed. Generally they're subject to removal by the Attorney General for cause. So that's how that office works. New section 3 then provides the purpose of the Office of the Child Advocate. It's essentially to receive and resolve complaints from legislators and from persons involved with the child welfare system, alleging that DCF, one of their contracting agencies, or DOC, has provided inadequate protection or care of children. And they also assist the legislature in conducting oversight of the child welfare system. And they receive complaints that allege those acts or omissions that I just mentioned. And then they independently investigate those complaints if they reasonably believe the complaint's allegations may be verified through an investigation. There are a number of provisions about what happens during that investigation there in section 3, and also some provisions about being granted access to reports, records, and other information as provided in that section, and then in the amendatory sections 7 through 11 at the end of the bill. New section 3 also has a specific provision about assisting the legislature in oversight of the child welfare system. They can meet and discuss items, of course, with the new committee we're about to discuss. They review statutes, rules, and regs. They evaluate the effectiveness of and recommend changes to procedures about reports of abuse and neglect. They review law enforcement investigative procedures and make recommendations on those. So a number of tasks and obligations for this office. Finally, I'll note that employees of the agencies that this office will interact with are required to assist the office in the office's duties. So there's a specific statutory obligation for employees of DCF, DOC, et cetera, to assist the office. New section 4 then provides that for any information obtained from a state agency or other entity under this Child Advocate Act, the office is subject to the same state and federal statutory disclosure restrictions and confidentiality requirements that are applicable to the agency or the other entity that they get the records from. There's also a number of other confidentiality and records provisions in this section. And some of those would expire, of course, in 5 years unless the legislature reviews and reenacts them under the annual Open Records Act review that you're all familiar with. New section 5 then provides that no retaliatory action can be knowingly taken against any child or employee of DCF or DOC for any communication made or information given to the office. There are a couple of exceptions to that, but violation of that retaliatory provision is a Class A non-person misdemeanor. So that's in section 5. Section 6 establishes the Joint Committee on Child Welfare System Oversight. There are about 11 non-exclusive topics that the office reviews and considers. A couple of the major ones I'll highlight is a review of the annual report that will be submitted by the Office of the Child Advocate to the legislature, and also reviewing and approving the budget of the office, which then goes to the Attorney General and becomes part of the Attorney General's budget that is given to the Director of Budget. So those are a couple of the main highlights there for you, but there are a number of others that the committee will do. The committee consists of 13 members, 7 House, 6 Senate. The quorum would be 7, of course, and they're required to meet at least once during each of the first and second calendar quarters when the legislature is in session, and at least once during each of the third and fourth calendar quarters on call of the chairperson, but not to exceed 6 meetings in a calendar year. So they will meet fairly regularly. Then finally, sections 7 through 11, I won't go into the details. I've outlined them in the brief, but each of those provides access to specific records that are confidential or privileged or otherwise restricted under the Code for Care of Children, the SYNC code, or the revised Kansas Juvenile Justice Code, the Juvenile Offender Code. So that's what those amendatory sections do, is grant the office access to certain records that are otherwise confidential or privileged. And with that, I'll stop and see if you have any questions.
Mr. Thompson, committee questions for the reviser. Senator Haley.
Thank you, Madam Chair. I know we have conferees here to hear from. I'm just trying to ask in a general, larger snapshot, if there are any other, Mr. Thompson, if there are any other pending bureaucracies or commissions or committees that you're aware of that we're implementing. I do understand this one's related to child welfare, but are you aware of any other bureaucracies that are in place or that are pending at this point beyond this one?
Mr. Thompson.
Thank you, Madam Chair. Jason Thompson again. And if I understand the question correctly, I mean, there are a couple of bills being considered by either the House or the Senate that would establish this same joint committee. There, of course, was a report in 2019 from a child welfare system task force that is being circulated around. There's been some recommendations considered by the legislature. In fact, one of the duties of the joint committee is to look at implementation of the 2019 Child Welfare System Task Force report and those recommendations that they made. Those are the major ones I'm aware of. If there's anything else, I'm sure the conferees or maybe some of the members of the committee have some more insight.
Thank you, Mr. Thompson. Thank you, Madam Chair. I'll reserve the question for afterwards again. You know, if there's something beyond child welfare, some other area that there's an expansion or desired expansion for oversight. Thank you, Madam Chair, and thank you, Mr. Thompson.
Thank you. Committee, other questions for the reviser? Seeing none, then we will invite our first proponent conferee to the podium today. And since we're considering Senate Bill 301, I will invite Ty Masterson, Senate President and Senator from the 16th District. Welcome, Mr. President, to committee.
Thank you, Madam Chair. Thank you for the opportunity. Thank you, committee. I will be brief in my remarks. I'm really just here to kind of highlight the need for this particular bill, because these conditions exist, right? So there's really important factors that we need. We need independence and we need impartiality in these reviews, because what we have underlying is the human condition. And it doesn't matter. I've now served under, with Governor Kelly, 5 governors. Actually, I think that makes 3 Democrats and 2 Republicans. These conditions exist under all of them. Now, I'll concede that media portrayal of these situations change depending who's in office, but we don't need to concern ourselves with that. We need to concern ourselves with the children that are under and in these conditions. So that's what I think the most important thing about 301 is that independence and impartiality. And then beyond that, the tools to do what that office needs to do to protect the kids. Because we truly need that removed to the best of our ability from politics. And if you leave that under a governor's office, or even under the legislature, for that matter, we act at times very politically in nature because of the nature of a republic and the elections. And so we try to leverage situations. And I say I've seen it under every side. And so we want to remove that to the best of our ability and get down to how do we best become a voice for these children that are in these situations? Because it does exist. So there needs to be independent accountability. There needs to be the tools to do the job. And we think this lays out a good path for that. Now, I trust this committee to work through it. If there's ways to make it better, great. But the key is to create that independent voice to protect the vulnerable, because it is the human condition no matter who's in charge. With that, Madam Chair, I'd stand for questions.
Thank you, Mr. President. We'll go ahead and reserve our questions till after we've heard from all the proponent conferees. Thank you. Next, we have Mr. Derek Schmidt, Kansas Attorney General. Welcome again back to committee.
Well, thank you, Madam Chair, and members of the committee. It's very good to be back with you. You got my written testimony. Of course, I won't read it. Let me just say why we're here. I think this is a very good idea. The concept of an independent child advocate, I think, has broad support among folks who might lean a little further right and folks who might lean a little further left, and others who don't view this as a philosophical issue at all. I've heard from folks across the spectrum. We're involved in this because the President had asked for our input and others had asked for our input on how this might be accomplished. And obviously we have folks that work on the enforcement side. We aren't DCF, but we do a lot of child crime work, child abuse crime work in our office. And so we offered input. And, I guess I would just say a couple of things. It seems to me as you figure out how you want to proceed here, from our vantage point at least, it is important, I think, that if you're going to do this, you do it in a way that gives the office actual independence from the entity it's supposed to oversee. And there are different ways you can do that. This bill proposes to do it by attaching the Office of Child Advocate to the Attorney General's office. That is one model that accomplishes independence because you're in a different chain of command, so to speak. The House has a proposal that attaches it to the Legislature. That's a different way you can accomplish it. I've mentioned in my testimony some other examples of policy areas where the legislature has decided to set up independent entities and pointed to ways that that's also accomplished. So that's one. But if you don't make it independent, I really think you're winding up spinning your wheels. And we saw that on the Office of Medicaid Inspector General, where it was proposed way back, the details are in my testimony, but it was proposed way back in, I think it was 05 or 06. And the original concept was make this thing independent from the Medicaid program by, at that time, the original idea was attach it to the AG's office. That didn't fly at the time, and so the legislature attached it to the Health Policy Authority, and then it was later rolled from the Health Policy Authority into KDH&E, and then you had the program being overseen and the overseers both in the same chain of command, and that was not particularly healthy. It was actually a legislator who came to me a few years ago and said, could we move this to the AG's office to establish that independence? And I, of course, said yes, and by the way, here's the history. That was the original idea, and you did that, and we're now making that work. So that's one. I think it needs to be independent. The second thing I would really emphasize and encourage you to consider as you move forward with whatever you do, I would really recommend you have clear direction in the statute on what you want this office to do. Just saying help kids, and this doesn't just say that, but I mean just saying help kids, that is not a precise mission. And you got to have a relatively precise mission coupled with correct tools and resources to accomplish that mission, or else you wind up with this real disconnect and a thing doesn't work. And we've experienced that too in the Abuse, Neglect, and Exploitation Unit, which was created after the Kaufman House case in 2007, if my memory serves me correctly, where there was a desire in this building, I was here at the time, to do something, to have some sort of independent review of those types of abuse cases. And so the result was the A&E unit. And the concept was make it independent. They did. They attached it to the Attorney General's office. That was the model that was chosen. But we didn't right-size the mission with the tools. And so when I got to the AG's office some years after this was created and I was able to see it from that side and try to make this thing work, we realized we didn't have clear guidance on what we're supposed to be doing, and we didn't have meaningful tools to do much of anything other than literally our folks would sit in the room with the agency they were supposed to be overseeing and ask for information and sometimes beg for information, but never be able to compel the production of that. So we came back to you a few years after that, once we had a grasp on that disconnect, offered up some suggestions on the way to square that up. You chose one, you did it, and I think the unit now actually performs pretty well. It's a more limited footprint, but what it does pretty well. So those would be my two overarching suggestions, and then we have Deputy Attorney General Steve Carr here. Steve has a lot of experience in this area, and he can talk about particulars if you're interested why we recommended this or that. I'd be glad to stand for questions or sit down.
Sure. Thank you, Mr. Attorney General. Committee, we usually take committee questions after we've heard from all proponents. I think it would be helpful for committee to hear more details. Okay, yes, that'd be great. Thank you. We have a request from a representative who wants to testify out of order today, and I'm just concerned that we're balancing a few things here, but we need, I think, to learn more details about the bill before we hear from an opponent. So with that, we're going to move to Mr. Steve Carrere, Deputy Attorney General. Please introduce yourself and welcome to committee.
Madam Chair, thank you, fellow members. My name is Steve Carr. I'm the deputy in charge of the Fraud and Abuse Litigation Division. I have been in that role since 2016. Prior to that, I was in the Criminal Litigation Division for just about 10 years. I have prosecuted child abuse cases and sexual abuse cases and child homicides. Also, I served as the chairman of the Child Death Review Board, and as indicated by the general, the A&E unit has been housed within the Fraud and Abuse Litigation Division since 2016. So it's with that experience that I testify before you today. My goal here is to talk about the authorities given in this bill and to speak to not the policy decisions, but that the authorities and the remedies match the policies you make. I'm going to speak in three categories. One, the initiating mechanism to which the review occurs, the remedies that are available, and then the investigation authorities. First, the initiating mechanism in this bill is by complaint, meaning an individual can file a complaint. That is important because it's different than any initiating mechanism that we've had before. In the A&E unit from 2006 to 2016, the initiating mechanism was substantiations. So if DCF substantiated abuse, they were required to forward that substantiation to the Attorney General's office. That was reviewed by the A&E unit. The problem there, or one, maybe not a problem, but one of the realities of that, let's say someone had a complaint that said, look, this child is being abused, but DCF didn't substantiate. They unsubstantiated, and they're not doing anything about this abuse. I'm not saying that was correct. I'm saying that's the complaint. There was no authority in the statute for the A&E unit to review that. This initiating mechanism that in 301 would allow for that. In other words, somebody could make a complaint saying, look, this child is being abused, but DCF hasn't substantiated it. The second piece, Child Death Review Board, their initiating mechanism for review was the death of a child. So yes, in those cases, there were often instances where we reviewed unsubstantiations of abuse. But of course, that was only in the cases where a child had died. This initiating mechanism would allow all of those. Next is the remedy section. So whatever your public policy is, I just ask that it be clear as to what you expect the Office of Child Advocate how you expect them to remedy the situation. For instance, with the A&E unit, the Child Death Review Board, and even legislative post-audit, their real remedy was the ability to recommend changes to the legislature by issuing a report. I suppose they also had the ability of the bully pulpit, but frankly, in my experience, that was very ineffective. That did not result in change or changes in specific cases by DCF or other agencies, their contracting agencies. So in this bill, it expands those remedies. The other thing to keep in mind, if all you have is a reporting function, that only looks prospective. It does not look either retrospective or at the current case. So if you decide that you only want to give reporting authority to the Office of Child Advocate, just be clear that that would not necessarily match the mechanism. So the mechanism is the individual is able to make a complaint. They're making not a complaint generally about the entire system. They're making a complaint about a specific situation. And when they make that complaint, they will expect that that specific situation is remedied. If all you have is a reporting function, if the child advocate only has a reporting function, every one of those complainants is going to come away upset because their individual situation is never going to be addressed specifically. Maybe it's addressed in the future through legislative change or policy change, but that specific situation is not going to be remedied. That brings me to the third piece, and that is the investigation piece. So in here, there's quite a bit of investigative authority. And I think some of the opponents might object to that. I'm not here to say whether that's perfect public policy or not, but the reasoning behind those authorities is if you are going to conduct a thorough and effective review of not only the system, but that specific situation, you are going to have to obtain a lot of information. You're going to have to not only obtain records, but be able to require people to talk to you. One of the specific things in this statute allows for the Office of Child Advocate to speak directly to, say, the individual social worker. I can speak from experience that one of the issues that the A&E unit constantly ran into was they were not allowed to speak to individual social workers. They might have to talk to a supervisor or a supervisor, right? And I can understand that from an agency standpoint of trying to narrow who communicates with the outside world. But from an investigation standpoint, that's not effective because yes, I can get the reports, I can look at the notes. I can assure you, as being a prosecutor for 20 years, not all relevant information is ever contained in just the notes and the reports. It's also important to speak to that person to find out all the information, and just as importantly, to find out the why. Why did they do this and not this? If you can't do that, and find out from the ground what the decision-making process was, it's almost impossible to judge whether that decision-making process was a failure of the system or not. And so the ability to obtain records, medical records, psychological records, are all important. For instance, one last thing, let's say the complaint is what I talked about before, which it is, this child is being abused, but DCF has unsubstantiated it. We think they're continuing to be abused, and DCF's not correcting it. If the child advocate was put in the place to receive that complaint, one of the first things they're going to want to do is see the medical evidence, see the psychological evidence, to see if that child, in fact, has been either physically or mentally abused. if they don't have ability to obtain that information, especially if DCF did not obtain it, then I don't know how they would ever be able to determine whether there was a failure or not. And so, again, I just ask of you that in each of those categories, when you make the decisions about the public policy that you want to pass, that the authorities, the resources, and the remedies match and give that to the Office of Child Advocate, so that they're able to carry out your wants and wishes, not to come back later and say, well, we failed and here's why, because we never had the power to do what you wanted us to do. Thank you, and I'll stand for questions at the appropriate time.
Thank you. Committee, we have been requested to take testimony out of our usual order, and today I'm going to grant that request from an opponent conferee who is Mr. Jared Ousley, representative from the 24th District. The reason we're taking it out of order is because the House is in session on the floor at 11 o'clock, and he needs to get over there to the floor. So he will immediately stand for questions after his testimony, and then we will get back to our regular order of business for the conferees. So with that, please introduce yourself, Representative, and welcome to committee.
Jared Ousley, House District 24. Thank you for the accommodations, Madam Chair, Vice Chair, and Ranking Member Committee. I agree with a lot of what was just said. There's no argument that we need an independent Office of the Child Advocate. If you know me, you know I've been working on it for coming on 4 years. This year I thought we had a really good product over in the House chamber, and some people disagreed with me. The Joint Committee on Child Welfare Oversight, I think, is also definitely a necessity, and I think they go hand in glove. So I appreciate the Senate taking the House position on the membership makeup of that in Senate Bill 301. However, while it's labeled the Office of the Child Advocate, SB 301 appears to be styled more closely to an Inspector General's office if a state were to put an Inspector General's office that had unlimited authority to depose and subpoena with little to no oversight. To understand the purpose of the Office of the Child Advocate, I refer back to the work of the Children and Seniors Committee in the House that unanimously passed HB 2345 with appropriate safeguards, oversight, and respect for other longstanding regulations as they relate to child welfare. 2345 defined the child as a child within state custody or as identified in a child in need of care. SB 301 broadly defines child to any child receiving services, thus anyone accessing welfare services or benefits through the state could be subject to its jurisdiction, not just children in the custody or children in need of care. 2345 had 12 proponents, 1 neutral, 0 opposition. Again, as I said, it was 4 years worth of work. That was 4 years worth of work with DCF, with advocates, with individuals, with parental input, with judges, with teams of attorneys. It went through 1 round of judicial council review. There was quite a bit of work in there. 2345 puts requirements for the advocate in place. 301 prohibits who may be there, and that gives me pause for concern because I don't want this job, and I think it's maybe hard to recruit somebody that is willing to accept this responsibility and deal with these situations. That gives me pause there that we might be limiting our pool of applicants. 2345 defined the purpose and scope of the office and its definitions, defining the office as the advocate for children's protection services and a specific purpose to recommend policy changes and to investigate complaints made on behalf of a child. SB 301 provides for investigation of complaints made by legislators and does not reference the purpose of the agency. There was a lot of work to put intentions into words that went into 2345, as the members from the AG's office pointed out. The intentions they need to be specified. And quite frankly, I'm tired of taking complaints from people. I've got a file cabinet full of complaints over the years. My work on children and seniors, interim committees, oversight committees. I remember this room was the location for the first interim committee I sat on, and we spent 16 hours in this room in 2015, I believe, over a session of 2 days. It was the Foster Care Adequacy Oversight Committee. Finally, 2345 spread responsibility of the oversight of the Office of the Child Advocate between multiple branches of government so as to prevent consolidation of investigatory power into one politician's hands, with the Governor and Chief Justice of the Supreme Court dual appointing, the Senate confirmation, bicameral oversight committee, and with the Attorney General having the authority to bring suit to terminate if we had a rogue advocate. SB 301 places the ability to hire and fire not only the advocate, but every member of the advocate's office in the hands of a single politician, the Attorney General. This is the ability to hire and fire at will. It incentivizes employees to follow the commands of the Attorney General, as opposed to laying out a purpose and scope for the work necessary to ensure the safety of children. This gives me pause as well. Working to create this office, I've often been reminded with great power comes great responsibility, and this will be a powerful office when established. It has to be in order to execute the position and the charges tasked. Further retaliation protections in SB 301 are narrow in scope and do not specifically prohibit the Office of the Child Advocate from taking retaliatory action, unlike 2345, which specifically prohibits the Office of the Advocate from knowingly disclosing false information. In the wrong hands, the political powers granted to the appointee under SB 301 structure could be used to create further harm to vulnerable families most likely to experience interactions with the state, rather than observing and creating positive improvements to the state system as a whole. I strongly encourage the committee to amend this bill to substitute for 2345 that's been crafted with input, as stated previously, and has broad bipartisan support. Thank you, Madam Chair, and I'll stand for questions at the appropriate time.
Thank you, Representative. Committee, do you have any committee questions for the representative? Senator Haley.
I will not hold him long, Madam Chair. The House is in session. I see they're in now. Why was 2345 not blessed, or do you have any, would you care to briefly opine, Representative, on the procedures that didn't keep that bill alive? Did anyone request that? I see it did come through the committee.
Senator, I could speculate, and I think that's a fantastic question, but I can't give you an answer.
I'd like to follow that up and have the reviser explain to the committee. The Representative Conferee has referred to House Bill 2345. I looked it up while he was testifying. House Bill 2345 was voted favorably out of committee. It was on general orders, and it was, in legislative terms, killed on general orders. So if we could have the reviser explain how that happened. It was House Rule 1507. Mr. Reviser.
Thank you, Madam Chair. Jason Thompson with the Reviser's Office. Yes, the House Rule 1507 allows bills to be stricken from the calendar when deadlines arrive, and that was done to this bill and many others. So I guess you'd have to visit with leadership as to why it was stricken from the calendar.
Thank you. Committee, other questions for the representative? All right. Seeing none, then, thank you very much. Or you had a comment, Representative, or?
They're holding the roll for me.
Holding the roll open for you. Okay. Well,
thank you for the opportunity.
You bet. Thank you, Representative, for appearing today in committee. With that, then, committee, we will return to our proponent conferees, and we have our committee member, Senator Molly Baumgardner, Senator from the 37th District. So welcome to the podium, and Looking forward to hearing from you.
Thank you very much, committee chair and committee members. On July 10th, 2020, a 3-year-old girl, Olivia Jansen, was found buried in a shallow grave near her home in Kansas City, Kansas. Olivia's dad had reported her to be missing earlier that day, and that triggered an Amber Alert. Her mother was in jail for something very unrelated. That very same day, grandmothers on both sides of the family suspected Olivia's dad and girlfriend were to blame. I've called the cops, I've called DCF. DCF, said her step-grandmother, Elizabeth Jansen. Olivia didn't make it through the investigation process. Police say she was killed 18 days after her grandmother called DCF for help. There was no Office of Child Advocacy for Grandma to contact with her concerns. Olivia's body was bruised on her arms and legs, as well as severe bruising on her face, with a cut in her head and bleeding to the brain, which was determined to be the cause of death. Now, the week after Olivia's body was found, people rallied outside the KCK office of DCF, calling for the state to release a history of the abuse and neglect claims filed prior to her murder. This was the written statement that was released by the Wyandotte County District Attorney's Office. Mrs. Chanel Dupree is the KC Regional Director, and because she is the wife of District Attorney Dupree, she has always been conflicted out of Wyandotte County child welfare cases, which includes this case as well. All Wyandotte County child welfare matters are handled by DCF administration, not Mrs. Dupree. Any additional questions pertaining to the Department of Children and Families should be directed at the agency. At that time, a protester told the media, "The system failed this little girl." Now, a DCF spokesman said that the law allows them to release a summary of the case and summary of calls only after they've determined a child's death is due to abuse or neglect. Now, in late August, DCF produced a 533-page case file for the judge's review on Olivia's death, but that has not been made public. The public has no access. During the joint interim foster care committee that met 6 times this fall, we were told as members by DCF that they couldn't provide any information about their role due to an ongoing internal investigation. So let's fast forward to today. We have 67 foster children missing. Today, 67 kids in foster care are missing. 58% of those are children from St. Francis placements. And yep, that's the same contractor with DCF that we know to have falsified their home visits and misrepresented their financial standing and shared inaccurate information during their presentation to the Joint Interim Foster Care Committee this fall. And let's not forget the class action lawsuit that revealed that children weren't just spending nights in offices, but they were also spending nights in hotels and cars and the homes of placement workers. The reason I stand in support of Senate Bill 301 is it allows the OCA to receive and resolve complaints. That's on page 2 of the bill. It allows OCA to independently investigate complaints on page 3 of the bill. It allows OCA to make recommendations to DCF and to contracting agencies. That's on page 4 of the bill. It allows the OCA to evaluate effectiveness and recommend changes in the procedures of DCF and of their contracting agencies, page 5. It allows the OCA to assure protection from retaliation of whistleblowers, pages 6 and 7. Why is that crucial? Well, the reason we found out about what was going on with St. Francis falsifying documents and the misrepresentation of St. Francis's financial standing, that's because whistleblowers had notified internally, St. Francis folks, had notified DCF, nothing happened, and the public didn't know about it, and DCF didn't start their investigation until that same whistleblower contacted the media. Senate Bill 301 also forms that Joint Committee on Child Welfare Oversight. Now, in the Senate side, we've heard Senate Bill 120. In fact, we passed it. I think it was one vote shy of unanimous. There's also House Bill 2115 that has been passed on the House side, which also is where that language for the Joint Committee on Child Welfare Oversight is found. Almost identical, just lifted and dropped in. I think Senate Bill 301 is an important step in improving needed transparency. It opens critical independent recourse for those that have been rebuffed or the concerned families or employees within the agency and their contractors to report concerns and wrongdoing. Now, it's interesting, the opponent indicated his concern was too much oversight from a political entity, the Attorney General. The Attorney General might allow OCA to disperse false information. The Attorney General might fire without cause the OCA or all the staff working within the OCA. I would say that that would be political suicide. So the concern that it's political, I think the fact that it's someone that is independently elected, not appointed by the governor, not appointed by the courts, but it's in an independent office is what is crucial. I know that the question was raised, why didn't this pass out of the House? I will simply tell you that this past fall, when we had those joint meetings, House and Senate, as far as foster care oversight, the chair, and I served as vice chair, but the chair from the House indicated not only to our committee, in fact, she refused to have a hearing about that in our committee, but she also went on record in a media interview that now is not the time for OCA. And I would simply tell you, if there ever was a time, it is now. We need the Office of Child Advocacy. I know that some of the neutral testimony we're going to hear, some of the opponent testimony is going to be a little concerned about, we need to fix this, we need to fix that. I know one of the concerns is sharing medical data on foster kids. And let me just say, what we have heard repeatedly is foster parents never receiving medical information on the foster children that they received. So this concern about sharing information, that is a problem that I know that the OCA needs to help us resolve. Thank you, Madam Chair. I'm happy to stand for any questions.
Thank you, Senator. I will now ask for, are there any other, proponent conferees in the committee meeting room or on WebEx? Seeing and hearing none then, committee, we will open it up for questions from the committee for any of our proponent conferees. Senator Corson.
Thank you, Madam Chair. My question is the concern that I have about how, because I think perception of this office is going to become the reality, and one of the concerns I have is, and this is not at all involving the individuals, but I worry about a perception where you have a child advocate who is selected by a Republican Attorney General who is running for governor, who is confirmed by a Republican Senate, who is then going to be charged with oversight of a Democratic administration. And again, not to say that this is that it involves the personalities, but I think that that will be a damaging perception among the public. And I worry that this person is not going to have credibility because whatever they say will be seen in the public and in the media as this is the Republican Attorney General who is going after the administration of his political opponent. And likewise, I worry that it will even give the administration the ability to discount what could be very viable findings from that office, because the administration will just be able to say, oh, look, there's nothing here. This is just politics. This is just my political opponent in the midst of a campaign. And so I'm deeply concerned about that because I think the public perception of this office is the reality, like it or not. And I want to see if any proponents could maybe speak to that concern that I have. Thank you, Madam Chair.
Thank you. I guess that's a concern, not a question, but if any conferee wants to reply. Yes, Senator Masterson.
I'm glad to address it because I'm not running for anything. So I think there was a mischaracterization that the responsibility was to hold the opposing administration accountable. That's not the responsibility. The responsibility is those children. Right? It is to have an independent, impartial voice for the children. And we are I will concede, we're in a political world, right? And you see this, but the perception becoming reality, it would only be because you would be building that perception. Right, that this person is not independent or that this person is not qualified, trying to tie it into the political system. But that exists. So is the alternative then leave it inside the governor's office, where you really have kind of the fox guarding the hen house? Whoever's in the governor's office, Republican or Democrat, where you have somebody that then has a political motive not to let that come to light. There has to be a separation in that, because if you leave it under the governor, or even the legislature, as you well know, we are involved in politics in a large way, right? And we do that every 2 years because of the way the House's elections come. So it is imperative that it be pulled back and be independent. Can those perceptions be created? Absolutely. But that is not the goal. The goal is to protect the children, and I think this is the best we have to do that.
Thank you, Senator. Senator Gossage.
My question is for Senator Baumgardner. Thank you, Madam Chair.
Sure. Senator Baumgardner, do you want to take the podium? Thank you.
Would you mind taking that same example of this young child and horrible things that happened to her and how it would have been different had we had this department?
What has been reported in the media with regard to Olivia is that grandparents contacted law enforcement as well as DCF multiple times, and there was not action. We do know that at one time DCF went for a visit, and with that quick site visit, didn't see an indication of physical abuse. When they were contacted repeatedly, we do know that there was, rather than a physical visit, there was a virtual visit. And that was simply so that the father would have to take a drug test. And I will tell you that a week after I was elected to be a senator, the first call that I had received was with regard to a DCF issue. And it was with regard to a family that had had a small child in foster care since the child was born in prison. They had had this foster child for more than 3 years, and there were significant problems with what was going on with regard to DCF. We know that at least in 2021, what's been reported by DCF is the maximum number of days that a child has been in foster care prior to reunification was 2,269 days. For those mathematicians, you know that that's just over 6 years. And so there are issues, but your choice is to contact DCF, and I've heard from foster parents as well as natural parents whose child have been taken into foster care, that is almost like a black hole or an abyss, and there is not much response or assistance, or to contact the media. That seems to be the only recourse. And so I do believe that the OCA will help circumvent and help come up and make recommendations for solutions to the problems that we know are within an agency. And to be clear, Kansas is not unique in having problems with foster care. That's true in every state. But this is part of, I believe, a significant part in the steps we want to take forward so that we don't always have about 7,000 kids in foster care, so that we don't have a graduation rate of foster care kids that is under 50%. We need outside help, and with regard to the concerns of the appointment, we can have 5 people, we can have 6 people, we can have 7 people on that hiring committee. But ultimately, we know that when a child death occurs, whether an accident or at the hands, what we would consider murder, it is the Attorney General's office that's responsible for investigating that. That is why I always believed that this office should be housed in the Attorney General's office. They are always responsible for addressing any death of a child, and likewise, they, day in, day out, are responsible for handling confidential information. And that's exactly what the OCA will be doing, handling confidential information, but working to prevent child death.
So if I may, Madam Chair, so what I hear you saying is it would not only have given this grandmother another recourse, but also give oversight into the DCF as to why they have not addressed this, and perhaps this child could have lived.
Yes, and Madam Chair, what that also would have done is it would have provided perhaps internally a recommendation for action that should be taken in the future. So we always want to look back at what's occurred, and we want that to be informed to new changes in process and procedure.
Thank you. Committee, other questions for our proponent conferees? Yes, Senator Thompson.
Thank you, Madam Chair. Actually, Senator Baumgartner, sorry about that. Do you foresee, you talk about the recommendations for children, do you foresee a situation where some kids are in immediate danger where that office could take immediate action in lieu of a recommendation to DCF to prevent something like this from happening?
Senator Baumgartner.
Yes, thank you, Madam Chair. Molly Baumgartner, Kansas Senate 37th District. I believe that this is a set of independent eyes, and there are times when there is not trust, oftentimes in our state agencies, and so them having that hotline might be that ability to contact law enforcement, contact DCF, and say, this needs to be rocket docket. You got to get this at the top for most immediate address.
Thank you. Thank you, Madam Chair.
Thank you. Senator Haley.
Thank you, Madam Chair. And first, an observation. Wyandotte County has been certainly the flashpoint of some of these issues that I think that this purported commission would want to address, not going to the media, but having an independent advocacy for children. So I do want to say, though, that what was very well vetted as between our district attorney and the governor's appointee to the region, it came up during a campaign season. It was well vetted, and there was little merit to any conflict of interest between our district attorney and his wife. There were many who did allege and went back to that these cases, as has been pointed out, come up all the time, not just in Wyandotte County, but all over. I think the general mentioned Kaufman. I remember that horrible, but that certainly wasn't Wyandotte County. The predecessor at one point was Secretary Gilmore under another administration. And many of these cases, as some will remember here, during that secretary and her predecessor, a gentleman out of Florida who went back to Florida, name began with an S, the secretary, but he was here for a moment, came up, and during Wyandotte County, there was a case during that administration where a young boy ended up being actually in a pig trough, fed to pigs, and it made national news. And so my concern, and the preface these comments are, is that my concern is if we implement this, and I haven't read is at 2345, is the very real concern raised, I think it was Senator Corson, is the politics of it. And looking at this, how do we lift the perception that this is pure political imbalance when a commission is named that will be heavily partisan by the way it's outlined, on page 8, who the members will be, any less so than we do these allegations that there's partisanship in whomever the governor appoints or whomever is responsive or irresponsive to these concerns, these sad truths that make the media, and the many in between that don't make the media but are equally tragic. I guess you said, is there a question in there somewhere? But there kind of is. I'm concerned about the makeup of this commission. I don't care if it's housed with the AG. I mean, frankly, I'll say, because the AGs are going to come and go, the governors are going to come and go. But I am concerned about putting a commission in place that is heavily partisan, that may reflect what attorneys generals do, and how we make that less partisan in their implementation. And the second point would be when this is actually implemented. So maybe we could not have it begin this year, but some point subsequent when we're not in a politically charged environment, as we will be in the upcoming year.
Thank you. Do we have a proponent conferee who wants to respond? Senator Baumgardner?
Thank you, Madam Chair. I think that the good senator from Wyandotte is making reference to the Joint Committee on Child Welfare Oversight. That would be, I believe, on page 8 of the bill. Is that what you're concerned about? Or is it the Office of Child Advocacy that you're concerned about?
So on Senate Bill, Madam Chair, Senate Bill 301, it starts the Joint Committee on Child Welfare Oversight. Yes, that's correct.
Thank you, Madam Chair. Senator Molly Baumgardner, Senate 37th District. To be clear, the Senate has already voted on that, and I believe it was, we had 2 nay votes on the makeup of that committee. So the Senate has already voted and taken a position on that. Likewise, the House has already voted on that Joint Committee on Child Welfare Oversight as well. It was modeled after, I believe we refer to it as the Bethel Oversight Committee. It was modeled exactly over that. I would note that there are, in this version, in Senate Bill 310, there are 2 additional members, one from the House and one from the Senate. That would be the only way that it differs from what is already passed out of the Senate, and that would be Senate Bill 120. So with regard to representation, I'm just going to remind the committee that when we are talking about foster kids and kids that have been in and out of our system, those are our most vulnerable children. They are wards of the state. It is our responsibility to make sure that they are safe, that they are protected, and that they receive the services that they so desperately need and that they deserve. And I have really never seen disagreement on the 2 different foster care joint oversight committees that I've served on. I have never seen that as a partisan issue, because the foci has always been what's best for our vulnerable Kansas kids. And I've been a participant of that oversight committee. You know, I've been a senator and we've had 3 different secretaries that oversees DCF. And I've been a proponent of this through all 3 of those secretaries. I am convinced that with regard to the issues facing foster care in the state of Kansas, it doesn't matter who's in the second floor. It doesn't matter who is Secretary of DCF. Because for the most part, we are using the same contracted agency groups. For the most part, we have the same group of folks that are cycling kind of throughout that agency. And so it becomes an issue of we need to change the way in which we are doing things. What is the process? What's the procedure? How can we better serve these families and these children?
Thank you, Senator. Was there another proponent conferee who wanted to respond? Seeing then none. Committee, any other further questions for our proponent conferees? We do have some neutral conferees and one more opponent conferee that we would like to hear from today. So with that then, we will invite our neutral conferee after introduction, Ms. Tanya Keys of the Department of Children and Families. Ms. Keys, please introduce yourself and welcome to committee.
Thank you, Chair Warren and Vice Chair Wilburn. I'm Tanya Keys, Deputy Secretary for the Department for Children and Families. Thanks for an opportunity to be able to speak about Senate Bill 301. As you've been hearing, this bill establishes the Office of Child Advocate within the Attorney General's office. It's going to receive and process concerns from individual families, legislators, or the public. It also establishes a joint committee on child welfare oversight. DCF is neutral on Senate Bill 301. We support the creation of a joint committee on child welfare oversight. We support establishing an Office of Child Advocate. We have concerns with organizing the Office of Child Advocate within the Attorney General's office. As you've been hearing, I mean, the primary function of the Child Advocate is to support children and families with Department in child welfare, as well as juvenile justice, when those families might have a concern about something that didn't occur appropriately. They're going to be able to look at case-specific or family-specific issues, as well as help us with insights into broader systemic reform and improvements. It's an important function. It's going to strengthen existing oversight of child welfare. And as you've been hearing, it's very important for it to be an independent advocate. There's little precedent nationally for organizing an Office of Child Advocate under an Attorney General's office. According to National Conference of State Legislatures, there are about 22 states who currently operate, some form or fashion of a children's ombudsman or an Office of Child Advocate. One state, Nevada, organizes it under the Attorney General. Many of the states organize it either within the governor's office or an administrative agency. DCF recommends the Kansas Office of Child Advocate really instead be placed as an independent office under the Department of Administration, similar to the existing long-term care ombudsman. The current long-term care ombudsman has similar functions of receiving and investigating reports concerning the long-term facilities that are regulated by KDAD. So we know that independent oversight of executive branch agencies can be accomplished, housed through the Department of Administration. The legislature would still be involved in the selection of the advocate. You'd still receive reports, and there'd still be Senate confirmation. Additionally, the joint committee would continue to work with the legislature. Also, part of our worry is that the focus of an ombudsman or an Office of Child Advocate is really to support citizens who might have worries or concerns or complaints. DCF believes strongly that organizing this type of an office within a law enforcement agency, it may be a barrier to some families or individuals coming forth with their concerns. Finally, DCF wanted to bring about a technical piece. We would suggest that the definition of child be narrowed because right now, as it reads, the child has an open case as a service that could be interpreted to include cash or food assistance or even childcare within the Department for Children and Families. So we would ask for consideration should this bill move forward to narrow the definition of child, and we've set forth some information there that might be helpful, and we'd be happy to work further on that. Again, we support the joint committee, and over last summer and fall participated in the special committee for oversight of foster care. The effects of the legislation will be additional tasks for DCF to help receive and process and respond. We will also be required to post notices of contact information for the Office of Child Advocate in our buildings, as well as any facility that is supporting children being placed. So we would proceed with that. We think that will have an impact on us of 3 full-time employees to be able to respond and coordinate with the Office of Child Advocate. I mean, in summary, in order for the office to really fully affect its responsibilities, it should be housed in the executive branch in the Department of Administration. We support the Office of Child Advocate. We would be able to support the bill if the committee would consider making a change to having Office of Child Advocate housed within the Department of Administration. Thank you, and I'm happy to answer questions when appropriate.
Thank you. Next, we will hear from Kyle Kessler, Association of Community Mental Health Centers of Kansas. Please introduce yourself and welcome to committee.
Thank you, Madam Chair, members of the committee. I am Kyle Kessler, Executive Director at the Association of Community Mental Health Centers. We represent all 26 licensed CMHCs across the state and appreciate the opportunity to appear here today to provide neutral testimony on Senate Bill 301. And I believe that a quick explanation for the reasoning behind our position also will act as a summary of our testimony. A neutral position on a bill for our association usually means that we just want to provide some additional informational or educational information to make the bill or initiatives stronger. In this case, it's part of the issue. The other parts are equally that we do believe that more attention to child welfare and recognizing that the leadership behind this bill in terms of wanting to see something happen, it's one of the only things, and I've been around health and human services public policy specific to child welfare and behavioral health for about 18 years. And this is about one of the only things we haven't tried to improve our system. So recognizing that there might be an office that would promote, again, independent of the executive branch, that would be a body that's trusted by the legislature and able to speak in a comprehensive way about policy improvements or practice or legal improvements that could be made could be very beneficial, as well as looking at some independent cases to try and move towards system improvement. So with that also being said, then the other side, we have some significant concerns that then could justify opposition of the bill. So we net out at neutral. And we've had some conversations about this bill just in recent days, and specifically to the confidentiality provisions for care provided to children and families. That's one of the cornerstones of health care, generally speaking, and especially as it relates to behavioral health in our system. And we know that people must feel safe and protected when accessing care, or it is a real possibility that they just won't. And so we know that over the years, the challenges to connecting the different systems to each other has certainly been present, and we think that this could be, in long term, a bridge to connecting those systems. And with that, I will stand for questions at the appropriate time, but conclude my testimony.
Thank you. Next, we will hear from Mark Fonkert, Kansas Appleseed Center for Law and Justice. Please introduce yourself and welcome to committee.
Madam Chair Warren, Vice Chair Wilborn, and other members of the committee, thank you. My name is Mike Fonkert, Director of the Just Campaign with Kansas Appleseed Center for Law and Justice. We are a nonpartisan, nonprofit organization dedicated to the belief that we can build thriving, inclusive, and just communities when we work together. We are neutral today on Senate Bill 301. And it pains me to be neutral today because as an organization that has worked for many years to achieve an Office of the Child Advocate, I would love to be a proponent, but unfortunately this bill leaves much to be desired. It goes without saying, I think the agreement is clear that the foster care system is in crisis. There's a lot of work that needs to be done, and independent oversight is a critical piece of that work. But that's where we start to look at Senate Bill 301. And that's the piece that's really missing here, is a true level of independence. Just for reference, according to the National Conference of State Legislators, Kansas is one of a minority of states that does not currently have either an Office of the Child Advocate, a Children's Ombudsman, or a statewide ombudsman program that addresses concerns related to children's services. The United States Ombudsman Association has established best practices for creating these entities and has said that independence is a core and defining principle of an effective and credible oversight entity. We've done analysis, and of these states that have independent oversight offices, with some focus on child welfare system, the reality is that multiple branches of government being involved in the appointment process leads to better results. In fact, those that have the most branches involved see the best results long-term in terms of decreasing number of kids in care and increasing levels of resolving complaints and concerns. So independence is really important here, and that's what we want to focus on for the committee. Under Senate Bill 301, the child advocate would be appointed by the Attorney General, exist within the office of the Attorney General, report directly to the Attorney General, be subject to removal from office by the Attorney General, have all budgetary powers controlled by the Attorney General, have all employees in the office hired and serving at the pleasure of the Attorney General, and it would have the Attorney General responsible for filing any findings of the OCA. Now, while the current bill language does specify that the child advocate would, quote, shall exercise independent judgment in carrying out the duties of the office, end quote, it's fair to believe that exercising true independence is difficult if one is appointed by, can be fired by, and all of their employees are hired by, and any report is filed by an elected official. Other concerns with Senate Bill 301 are numerous. One particularly, the bill specifies that no former or current executive or manager of any program or agency or contracting agency subject to office oversight be appointed within 6 months of the individual's period of service. We would strongly support modifying that language to prevent the revolving door between the OCA or the potential revolving door between the OCA and the agencies and contractors over which the office provides oversight. And at the very least, the time period of 6 months should be dramatically longer. But we would prefer to see, alluding to Senator Corson's comments earlier, oftentimes the perception of an entity is very important. And if folks don't feel empowered to reach out to the OCA because they see it as some sort of offshoot of DCF, that's going to really hurt the efficacy of the program. Also important to note, we have heard references to House Bill 2345, which was in House Children and Seniors and touched on, created a version of the Office of the Child Advocate. I would encourage every committee member to review the bill language, the amendments that were made to the bill, and the testimony that was given in support of the bill. As you can see today, we had a few proponents for Senate Bill 301, consisting of elected officials or their staff, but House Bill 2345 had dozens of proponents, former foster youth, families, advocates, and others that work in the system. There were no opponents to House Bill 2345, and we see opponents and those offering neutral testimony in an attempt to advance this legislation when we look at Senate Bill 301. Another piece that needs to be highlighted is on page 5, lines 33 through 35 of Senate Bill 301. We would ask to amend new section 3 I4 to apply to contractors as well as department and agency employees. Along with Representative Owsley and Senator Baumgardner and others that have talked about receiving complaints, Kansas Appleseed receives phone calls from people with concerns about the child welfare system all the time. And one group that we hear from are folks that work for contractors or DCF or others that fear retribution or punishment for speaking out about things that they don't think are right. And so we'd like to see contractors included in that section. You know, the part about creating the Joint Committee on Child Welfare System Oversight, we've already spoken in favor of in other settings, but the key here that I want the committee to really recognize is that we do need independent oversight. We do need an Office of the Child Advocate, and you all now have the potential to make this bill a good bill that will serve Kansans well. We are very fortunate that we have the state of Missouri's model next door. They have an Office of the Child Advocate. They've had it for a lot, you know, over a decade. They've worked through a lot of these concerns. The director of the Office of the Child Advocate for Missouri testified in support of House Bill 2345. A lot of work has been put into this process, and I would encourage you all to look at House Bill 2345 and work to make Senate Bill 301 as close of a reflection to that as possible. We definitely support changing the definition of child to make sure that we're focused on the right population of kids. Also, it would benefit this legislation to perhaps enumerate the reasons that that a child advocate could be fired for cause, or at least making that process more robust. Because the true mechanisms that are most important are independence and the authority to do the work to get to the bottom of the questions at hand. And again, this is so focused and so controlled by the Attorney General that we can't come and support this legislation in its current form. But you all have such a great opportunity here to make this bill better and really do something that's going to protect kids in Kansas for the long term. So with that, I will stop. My testimony has a lot of details in it that I encourage you to review, but take this opportunity to really put in the effort to make Senate Bill 301 as good as House Bill 2345, which you know, that language has been being vetted for multiple years and all sorts of stakeholders. So we have the templates to make this bill really effective and really positive. And I encourage you to do so, and I will stand for questions at the appropriate time.
Thank you. Are there any other neutral conferees in the committee meeting room or on WebEx? Seeing and hearing none, we will open it up for committee member questions for our neutral conferees. Senator Pyle.
Thank you, Madam Chair. My question's for Mr. Mark, the guy that just testified. And he mentioned a Missouri model, and he mentioned independence. Can you explain how the Missouri model is independent?
Please
Yes.
go ahead and identify yourself before speaking. Thank you.
For sure. This is Mike Fonkert, Kansas Appleseed. So the Missouri model has several checks on independence. The one that I think is most important to focus on for you all is that all three branches of government have a hand in appointing the child advocate. So the Supreme Court, the governor, and then the legislature confirms the selection. And in our analysis of the models that exist, that model in Missouri is one of the best, and that appointment process is one of the best. They also have a 6-year term for their child advocate. And so that allows them to have, you know, essentially to cross over the political, you know, election years and cross administrations. And so the focus in Missouri is really on appointing the best person that's going to do the best job for kids, and really leaving politics out of it, because by the time that advocate is up to either be retained or replaced, there's very likely going to be different legislators, potentially a different governor, even different Supreme Court members. So those are two really important checks that Missouri has in place, and their model is widely respected and viewed very positively by those that are working to improve the child welfare system.
Yeah, if I may follow up, Madam Chair. I guess my question would be, to achieve totally pure independence, we would need to create a statutorily elected office to where the people of Kansas would have a say as to who that child advocate is. Is there any state that does that?
So I can't say for
we have
sure. But
Natalie Nelson. Sure,
Mr. Falkert, please.
Sure, if you'll identify yourself, sir.
Yes, sir. Mike Fonkert, Kansas Appleseed again. To my knowledge, I don't know of any states that elect either a child ombudsman or child advocate. Not to my knowledge. I have not seen in the review of systems, I've not seen any that directly elect the position. It's all some version of an appointment. A lot of states, it's just the governor, directly appoints the position. And obviously we're a big fan of having all of those branches in, because when you look at the different models, the ones that are that have the fewest branches involved and are the most politicized, you have the least impact on the system. And so if you can preserve that independence and get the right folks and empower those folks to, in House Bill 2345, the child advocate is the one that staffs up and kind of oversees the employees, whereas this has the Attorney General overseeing all of that. And so really empowering the child advocate to embrace their role as purely an advocate for kids, no political concerns, no outside worries. They're just there to fight for kids. That's the best way to do it.
Thank you. Madam Chair, I do have a question for the reviser or research. I'm not sure who can answer this, but given the timeline of the bill, I would like to know if the bill were to pass, and I didn't look at the back, is it statute or register? What would be the soonest date that a child advocate would be in place? That's my question. What's the soonest date the child advocate would be in place to go to work?
Yeah, thank you, Senator. Do we have either Mr. Thompson from the revisor's office or Natalie Nelson from research who can answer?
Thank you, Madam Chair. Jason Thompson with the reviser. I can tell you the effective date is statute book, so it would be July 1st before such an appointment could be made. Then the person is subject to confirmation by the Senate. It appears that they might be able to use the Confirmation Oversight Committee in the interim to gain some ability to function. I'd have to confirm that with our confirmation folks based on the language of new Section 2, subsection B1, but they would be subject to Senate confirmation. So they could either be in that interim period or then January, when you come back into session, the second Monday in January of 2022, you would have the opportunity to confirm them.
Thank you, Mr. Reviser. Committee, other questions for neutral conferees? Seeing none, then we will turn to our opponent conferee. We heard from one. This is the second. Rachel Marsh, Children's Alliance of Kansas. Please introduce yourself and welcome to committee.
May I remove my mask?
Sure.
Good morning or afternoon, Chairwoman Warren, Vice Chair Wilborn, Ranking Member Haley, and members of the committee. My name is Rachel Marsh. I'm the leader of the Children's Alliance of Kansas, and I haven't had the pleasure of speaking with you yet this session, so I'll take just a minute to share information about who the Children's Alliance is, We're an association of 18 different child and family caring organizations that provide services from case management to family preservation. Our members are those who received Family First support to prevent foster care. We have members that manage psychiatric residential treatment facilities, provide inpatient and outpatient mental health services and substance use services. So our association represents the conglomerate of organizations that serve children and families as their core mission in a variety of ways in every county and community in Kansas. I also wanted to share a little bit of my background for those of you who haven't had the opportunity to meet in person. I am a lawyer and a social worker with a master's degree in social work, and I have worked in the Kansas and a tiny bit in Missouri child welfare system for over 20 years. I'm going to have to stop reporting out how long it's been. What I can bring to this conversation are probably going to be not helpful in the perspective of whether the office should be independent or how it could be independent, but more the very technical details of the work that I've done for 20 years, which is navigating the Child in Need of Care Code in light of federal laws, in light of other state laws and conflicts of laws. So I'm going to beg your indulgence to be that really boring lawyer who has really boring lawyer points to raise about this bill. The children's...
Please be concise if you can. We are running over now our committee time at noon, so just be aware of that. But go ahead. Thank you.
Thank you. I do want to say from the outset that the Children's Alliance was in support of HB 2345. We understand and agree that the challenge of navigating as a parent or a foster parent a system where the government has control over your child is very frightening. We want to make sure that what we do is preserve the rights of individuals as they currently exist while creating a right size advocate in whatever form that you might want to see that go. I actually very much appreciated both the Senate President and the Attorney General's comments about the need for it to be independent, the need for it to have a clear mission and scope, and the need to have the right size tools for a clear job. What I want to point out is some concerns in Section 3D6 particularly related to subpoena power. And this is seems minor, but it's actually very, very important for Kansas residents. This bill would not be introduced under the Kansas Child in Need of Care Code. It's a different code. It is also not under the Civil Procedure Code, and it's not under the Criminal Procedure Code. And so if you introduce a subpoena power with no link to any particular code, no person who is in receipt of a subpoena or a request to appear or a request to present materials would have a clear recourse. And so those families who are seeking support would be then kind of stuck feeling law enforcemented as opposed to supported as records are sought. So that is something that we believe is concerning to the extent this is the basis for my opposition as a child welfare attorney. I just couldn't, that was so critical that we get this right, that we don't accidentally extend any government agent into individual family life. There are approximately 80,000 reports of child abuse and neglect every year. So if the office can go issue a subpoena without government connection to process for all of those individuals, you've really infringed on individual liberties, and that's a concern of the Children's Alliance, because we're always balancing the rights of parents with the safety of children when we do our work. So we just wanted to raise that concern. The next points in my testimony relate to the fact that the civil discovery concepts in Section 3D6 are not actually utilized in the Kansas Child in Need of Care Code unless the court orders it, because we don't want to create a situation where, unlike many lawsuits that you hear, that you've experienced and gone through up here, that go for years and years and years, ideally, we want children returned to their families at least in 15 out of 22 months out of home. That is the federal standard. And so we don't want ongoing civil litigation getting into grandma's background, getting into the foster parents' background. We want attorneys to bring their witnesses, hear cases, and let judges make decisions. So we'd encourage you to consider whether the authority of the OCA should be more finely tuned in with that discovery section of the Kansas Child in Need of Care Code. Similarly, the Kansas Child of Need of Care Code 382210 has a provision not reflected in the bill draft here for free exchange of information between law enforcement and DCF. And for juvenile justice authorities. In my opinion, any Office of Child Advocate, to maintain consistency, clarity, and predictability, should be included in that free exchange of information rather than have a new access to records standard that hasn't been vetted, isn't clear, and may infringe in civil liberties. And finally, I did go and do some research about the language of this bill related to therapist privilege, physician privilege, because I thought, oh, I'm just being paranoid. It's not a problem for privilege. But in fact, I did find that privilege would be, there's no privilege if you're responding to a public record request or a request from a public official. And I don't believe that is the intention of how this bill is structured, that any person who might be sought, not necessarily because of their relationship with a child, but simply because their name came up, that their mental or medical records could be sought. I believe we want a more limited government in our state, or at least that would be our position. In contrast, when we talk about the right size tools, I would like to raise the importance of the definition of child in this bill or in any bill. The definition of child is critically important that we get right. We want the Office of Child Advocate to look at situations where a child is at risk of harm, as Senator Baumgartner really brought home. The risk of harm or fatality is unacceptable. We really must have them be able to look at a situation if that child is in danger. And some children are in danger who are not victims of abuse. They're in danger because of their own challenges, because other systems aren't meeting their needs. As many of you have heard, we have had an influx of children in the foster care system because of a lack of access to certain mental health services, IDD services, juvenile justice services. So we want to make sure that we use that definition is accurate to include those we want to include and exclude those with no connection to a child maltreatment or foster care candidacy risk. Finally, I want to point out that a critical foundation in our Child in Need of Care Code is the concept of child time, reflecting why we keep the discovery limited, why we try to move cases along for resolution of the child. A 5-year-old's experience of being out of home for 3 months can feel like 2 years to a 5-year-old. We want to make sure that we don't delay resolution for children and families that seek help, that the federal law of ASFA, Adoption and Safe Families, is followed, and that that principle of child time is respected. Finally, we would like to gently offer the suggestion that providers who have devoted their lives to child welfare in Kansas not be excluded out of hand as being unable to provide independence. I know for myself, I'm not looking for this particular job, but I would say that I would be unqualified for it, and I would like to think that many of my peers are highly respected in their fields and would be able to do this job well, and that we want to expand the capacity and the lens to a highly respected child welfare professional to ensure that we can spend the time serving kids and not learning a system of care that is actually quite complex. With all these concerns together, that led to our reason for being an opponent. We don't want increased conflicts, increased delay. We don't want to reduce morale because providers and employees don't know who they're supposed to respond to or when or under which code. We don't want to reduce confidence in the mental health system and increase turnover in our therapists and our child welfare employees. We believe that the concerns we've brought forth today are not inherent in the concept of an ombudsman or a child advocate, and that we can, if this committee and this chamber so chooses, seek something that is exactly as Attorney General Schmidt mentioned, right size to complete the scope and responsibility that this chamber is seeking. And with that, I will stand for questions and appreciate your time.
Thank you very much. Are there any other opponent conferees in the committee meeting room or on WebEx? Seeing and hearing none, then committee, we will have questions from committee members for our opponent conferee, Ms. Marsh. Any questions from the committee? Seeing none, then, thank you very much for your testimony today. Thank you very much to all our conferees who appeared in person and on WebEx today. Appreciate your input, and committee, your attention, as well as those following along online. With that, we are